Now, the location of a court case depends upon two types of jurisdiction. There's subject matter jurisdiction and personal jurisdiction. And the last and I want to go back for a moment because I talked about the federal court level, and I didn't talk specifically about the state court level because each state court is a little bit different. But there's still this three basic levels. There's a trial court level. There's the intermediate appellate court level, and then it's usually the highest court of the state. Normally, the lower court level, if I give the example of Florida, those are the circuit courts. And they have the circuit courts in different cities throughout Florida, and there's numerous circuit courts. In Florida, there's five district courts of appeal, where it goes over. Different districts have to appeal their court to a particular area. For example, in Miami area is the 3rd District Court of Appeal. In other areas, in the north me is the 2nd District Court of Appeal. There is up in the top of the state, in the panhandle of the state, is the 1st District Court of Appeal. There's 5 different courts of appeal. You might have to travel to appeal the case, but district courts of appeal are the first level of appeal. And then there's in Florida, there's the Supreme Court of Florida, located in the capital in Tallahassee, who is the final determination of what the state law says. Now, sometimes you can appeal a case from the state Supreme Court to U.S. Supreme Court, but those are limited in circumstances. I'd not go into that specific jurisdiction because, or that type of discussion, because that's something you would cover in another class. But know that the same basic format exists in both the state court and federal court level. But deciding whether a case goes to state court and federal court depend upon two things: subject matter jurisdiction and personal jurisdiction. The federal courts can only hear certain cases, and we're going to talk about that in a minute. They can't hear any case. They're courts of limited jurisdiction. The courts has to be a federal question, constitutional question, diversity of citizenship. We're going to talk about all that in a moment. So you have to have the court has to have subject matter jurisdiction. That means they have to be able to make a decision on the subject matter of what's being brought. Federal courts do not have subject matter jurisdiction over divorce. That's a state law jurisdiction. So you cannot bring a divorce case to a federal court because they don't have subject matter jurisdiction. So understand, the court has to have jurisdiction over the matter which is the subject of the controversy. And then you have to have personal jurisdiction over the parties. What that means is, and it mainly involves the personal jurisdiction over the defendant. For example, if you have a matter and let's give an example, you're driving through to North Carolina and you get an automobile accident. You live in Florida and you come back home and you're hurt and you want to file a suit against that person. You go to your circuit court and file a suit against them in Florida. Well, if this person from North Carolina has never been to Florida, has no residence in Florida, has no ties to Florida, the court has no personal jurisdiction over them and cannot force that person to appear in court. So we're going to talk about this in a little bit more detail about personal jurisdiction and subject matter jurisdiction. And we talked about the subject matter jurisdiction is granted to the court, federal court, by the Constitution, by the legislature. Bankruptcy courts have specific subject matter. A bankruptcy court, which is a federal court, can't hear another type of federal court case. Small claims court has limited jurisdiction. You can only if your case is if the small claims court says it handles all matters under $5,000, you can't bring a $10,000 matter involve $10,000 in a small claims court. Every court has its own limits of what it can and cannot decide. I mentioned before about personal jurisdiction. It's the power of the court to compel a party and require a party to appear in front of it. It means the case will be heard where the incident happens. Unlike subject matter jurisdiction, the party can waive this objection and choose to appear anywhere. For example, if a party agrees, from North Carolina agrees to appear in Florida court, he's availed himself of the subject matter, of the personal jurisdiction of the court. But if he doesn't, then the court has no way to force that person who lives in North Carolina, never been to Florida, has no ties to Florida, to come to Florida for the case. The person who files a suit automatically avails himself or puts himself in the personal jurisdiction of the court. So what that means is, okay, instead of filing in Florida, I filed a case in North Carolina, even though I don't live in North Carolina. I traveled through there, and the one time I was there was for the accident. If I filed lawsuit in North Carolina, I voluntarily have said to the court, I've given you personal jurisdiction over me, even though I live in Florida. Now, what makes a federal case? One big legal myth of the federal case are the ones that are most important ones, and then the states cannot hear the ones that are not as important. False. Absolutely false. Because just because a case is in federal court doesn't make it more important than the case in state court. A big case, just because it's a big case or an important case, does not mean it has to be heard in federal court. For example, murder cases involving murder in a particular state that are pretty big cases, those are all heard in state court. Not federal court, state court. Only time you see a federal murder charge is when you have a specific federal murder statute. The best example I can think of off the top of my head is the person who shot and wounded Gabby Giffords, the Arizona representative, and killed other people. That, since it was an attempt on a federal government official, that is in federal court, and all the other murders that correspond to it, since it was a federal gun offense, and it was at a governmental function, it'd be tried in federal court. But the state court could also try that person as well if they want. But they normally will allow the federal court to take over, the federal prosecutors take over those cases. State courts are not subservient to the federal system, and not all state cases can be appealed to federal court. In fact, there are very few state cases that it can be appealed to federal court. So don't get caught up in the myth that just because it's in the federal court, it's more important. That is not true at all. There are basically two ways a case can go to federal court. The first way is it involves a federal question. That means it involves a federal statute, something of national law, is a constitutional question. Or it's a criminal violation of a federal criminal statute. If a federal law is involved, or the federal constitution is involved, that case must go to federal court. And this is an example of exclusive jurisdiction. Now, sometimes there may be some state laws that are violated and federal laws that are violated. That's when maybe the court might give deference, allow the federal prosecutors to prosecute their case depending upon the severity. Sometimes because the state murder involved other federal laws involved in other violations of federal laws. The murder charge will go first, and then later the federal courts will prosecute it for the federal law violations if they're convicted or not convicted. Just know that there's certain things that the federal law or the federal courts have exclusive jurisdiction over. The second method of